send them to lunch now and not worry about it, but I'd still like to find out as to if she's going to be able to follow the law and whatever happens. I mean, I don't know if she's already on the jury, she's already been accepted. You answer all your questions. I think cross that bridge already.
Yeah.
So I don't know. I'm concerned, and I don't know how to.
And I understand and appreciate the court's concern, but the question is what is precipitating her anxiety? And it's the mask. And yes, we can clarify that with her. I have no problem doing that. But it can't be gangs because we discussed that at length during voir dire, and she cleared that hurdle and was put on the jury. Okay. But that would be our first proposition. If the court would consider that, that would be great. The second proposition would be the first of her two notes was a question. And it was, why can he see me and we can't see him? Which goes to the heart of the confrontation clause. And also lets us know that her concern is the mask. And the jury instruction that was proposed by the state and accepted by the court doesn't address the question at all. It says, considering like everybody else. Well, how are they going to do that? They're going to be instructed the way that they consider and is judging facial expressions, which they can now not do. We made we proposed a jury instruction, which the court rejected, and we would ask that the court at least consider whether or not it would offer some variation of that, such that the answer to the juror's question can be met, which is why. That's why. And I think they need to know that the why does not concern any issue with respect to this particular defendant. The third is the problem that we had before, which is, as brought out during Mr. Alistein's questioning earlier, the state could have chosen any expert in gangs. They elected to choose one who has threats against his life that don't concern this case and is undercover. And therefore that they have precipitated this problem. I think Mr. Mr. Melly, I think our client has a right to a jury of his peers, one which had been selected and seated, and his right to both confrontation and to a juror that has been seated supersedes all of the rights of the media, of the state to have an expert or a witness who could have been, and where they could have chosen any other expert. But our third proposition would be,
LinkedIn has allowed me to brand myself as a true professional. You have my credential list. You know who I am.
Or so, and we then bring her in and see what her problem is. If it's not the mask, I'd be highly surprised, but maybe that's the first step. But we ask the court first to reconsider, and second, to reconsider letting him testify in this fashion, and second, to reconsider reading an instruction that gives the jury a little bit more than he's testifying in a mask. Let's continue.
If you have an instruction that's agreed to, I don't really have an issue with it. My issue was the way you crafted this instruction is that I'm telling the jury that I'm looking at the media's right to be here over his right to confront his accuser, and that's not the way the way it was crafted and worded to me was not the right way to handle it, and I wasn't going to do it.
Okay.
All right. So the second issue that you had is having no witness, and it was justify without a mask. I don't have any issue with discussing that further with the witness. I did this because he told me he was in fear for his safety and his family's safety, and this is what he does for a living. And I made my decision based on that because this is being a live stream. I don't know whether or not he would how he feels about it, and I guess that's subject to further discussion. As far as taking a break, I think that's the best way to handle it. We'll take a break, give the juror an opportunity to go have lunch, and when she comes back, the first order of business that we can do is to talk to that juror about how she feels and whether she's able to continue. If everybody's okay with that, that's the way we do it. Proceed. Just see how she feels. If she's not suffering from anxiety anymore, if it's strictly an issue of the mask, then we'll know where that stands and we'll address it. And I can ask the witness then how he feels. So we'll take it one at a time. All right. So let's do this. We're going to take our lunch and recess now. Any objection, Gary? I told the jurors not to discuss the case. Just tell the jury to come back at, let's say, 1:15. All right? Or 1:30. Say 1:30. All right? Give her a chance to relax. And jurors back at 1:30. Okay? So,
quiet.
Attorneys to be back at 1 and 1:15.
I want some further discussion with you because counsel raised an issue about these text messages that are on the phone, and I'd like to see about getting some clarification for that. All right? So, Gary, you tell the jury to proceed back at 1:30. All right?
Okay. And there's one other thing, maybe, and I figured the last part of the jury instruction would be that with which the court took exception. And that's why I put it at the end, so it could be easily excised. We do propose that as the proper instruction, but we'd like maybe to copy the rest of what we have proposed so that the court can look at it over the break and the state can look at it over the break. I have excised that last portion and maybe we'd be better informed to discuss it upon return.
That's fine. So, regarding this witness, let's just, I don't know what the documents are, but I'd like to proffer basically how this is getting in. I understand there's an extraction, and I understand that was done, but I haven't seen what your proposal or the summary from the extraction was.
Here, I have this. If you want to look at them over lunch, I'd be happy to provide them.
Sure. You gave a copy of this to counsel?
Yes, sir.
Yes, we do that.
But these would be the ones I'd be trying to introduce as the color copies. They're the easiest to read.
So these are for what you intend to introduce at the time of trial.
Yes, sir.
All right?
There's also.
And so counsel's objection basically was, and again, to reiterate, I let the extraction in because it was taken from the phone. Defense's position is that there's no indication that it's the defendant, Jamel Demons' phone, and your position was that what's on the phone is evidence of who's had care, custody, control of who's using the phone. Am I understanding the argument correctly?
Correct, right. And so those messages go to show that as well. So there are some, for example, some pictures and things where pictures of the defendant and the other person in chat are talked about. That they're acknowledging that is who is communicating with one another. One of those photos has already been introduced. That was the photo that was authenticated by Felicia Holmes. That was the photo of the defendant and Frederick Gibbons, which is also known as Rito Bang. That is the approximately 50-page statement that you have in front of you. Other ones include, there's photos of the defendant with other individuals that are identified, and they're also cross-referenced with the emails that are sent to the defendant's email and retrieved on that same phone, as well as hundreds of photos, selfies, screenshots of the defendant using that phone.
With respect to the authentication, Your Honor, I think there's a little bit more nuance to our argument, which is it's not sufficient to say that the defendant used that phone at some point. I think there's ample evidence that that phone was used by more than one person. And the most poignant and striking evidence of that is that the phone comes back to the name Sack Chaser Howard. What that means, I know that my phone doesn't come back with the name Christine Bradley because I wouldn't do that. And I think that is a clear indicator that that phone was being used by others. And so the issue is not whether or not, if we can show that it was used by Mr. Demons at some time, everything comes in. The issue is, if you want to get in conversation A, prove that conversation A, lay the foundation for conversation A. Prove that conversation A was being had between Mr. Demons and somebody else, and that would be at least some measure of authentication. The case law does indicate that one of the two parties to the conversation is the way to go, and that's the way to authenticate it, but it's not exclusive. But each single conversation, as it's coming in, should be authenticated, because the fact that the phone was passed around and used by several others, we have presented the court with evidence that that phone was being used while Mr. Demons was in custody. We know it's being used by several other people. It's not in his name, and it wasn't recovered from him. And so the issue isn't whether or not he's ever used it. The issue is each conversation that you're trying to put in, authenticate it, lay the proper foundation so that we're not risking misleading this jury.
Thank you. And counsel, this is on this extraction report is all on the phone with the 9807 phone number, correct?
That's correct, Your Honor, and just so.
And that's the subscriber of that was Jamie King.
Yes, the
And
defendant's.
it's the information that's from T-Mobile, I forget the exhibit number, but which had subscribed and showed that this 9807 line was signed or used by Mr. Dennis, the defendant.
There's other information that the state has introduced, including the phone receipt in which Mr. Demons is identifying that as his personal phone number.
I realize that, but I'm
There's-
trying to go back to the subscriber information. I thought that was and I don't have it in front of me, but the plan was a family plan or something, and Ms. Jamie King had one phone, is that correct? And Mr. Demons had a different phone?
There are multiple phones on that plan, including one of the victim's phones that was used by the victim. Mr. Anthony Williams was on that same phone plan that Ms. King was paying for, but the defendant was using. And so in terms of any evidence that anyone else was using that phone, Your Honor, there's been proffers of things that were supposed to be said by the defense. However, there is no evidence before Your Honor that anyone else other than the defendant used that phone. And I'd be happy to put together over lunch a compilation of every single one of the screenshots that the defendant took on almost every FaceTime call that includes him in this small box, which would be indicative of who is using that phone, and the other individuals that he is calling as the larger picture.
Your Honor, some of the evidence is before you now, which is Mr. Williams, who was also on that plan, was also using that phone. His nickname was Sack Chaser. Right before you, you will notice that all of those messages are coming from Sack Chaser. I'm not claiming that that means that all of those messages are from him. I am saying it's proof dispositive that the phone was being used by him at times, or that would never have materialized in that way. And this notion that you go to a pawnbroker, yes, maybe the day that Mr. Demons was at the pawnbroker, he gave that phone number because he knew it was one he could reach. Just like last night when I went to go buy face cream for my wife, they asked, "Do you have a number with us?" And I gave them her number because that's the number that is associated with our Walgreens account to get credits. And when I go to Total Wine and they ask me, I give my number. And that's how that works. And so the fact that he may have identified that as a phone that he could be contacted at when he did a certain pawn transaction is not dispositive proof that he's the exclusive user of that phone. The fact that Sack Chaser's name is associated with that phone is dispositive proof that he was using that phone. And the fact that the phone was being used after Mr. Demons was incarcerated is also dispositive proof that the phone was being used by others. And the way that we can solve this is that the state can lay the foundation for each conversation they want to get in. And if they can't, it means they don't have the proof that it is him. If they can, then they do have the proof, and it should be admitted. But that's all we have.
Thank you. And the phone itself, when was the extraction done?
The extraction was done February of 2019, I believe February 23rd or 28th, I don't remember exactly, it's on the analysis. The report that is generated, which is what's been put in evidence, is generated in June of 2019. This was the phone that the defendant's manager brought to the state attorney's office and was identified during that conversation by the defendant's manager as being the defendant's phone that he was given after the defendant went into custody. There are multiple messages and things that I'm happy to show the court that because that item is in evidence, and I can put together a composite over lunch to show exactly the number of times the defendant is pictured on that phone, including the various accounts that have already been introduced, such as the Snapchat account, the email accounts, of which we have the Apple records and the certification on that for those phones, that it comes back to YNW Melly booking at gmail.com. And that email address, in the terms of when that was created, all of that is also subject to the search warrant, specifically which this witness looked at, which we can talk about the creation date of the account, which predates any of the activities in this case and all of the names that are associated with it of Jamel Demons.
So you're telling me the phone was turned over to the state attorney's office or the police on or about the date when Mr. Demons was arrested?
No, Mr. Demons turned himself in on February 13th of 2019. About 2 weeks later, his manager came to the state attorney's office to give a sworn statement and brought the phone with him. The passcode,
Mr. Francois?
Mr. Francois. The passcode to access that phone was given by this defendant in a jail call that I have, like I mentioned previously, to his mother, where he's telling her how to and what code is associated with the phone. That is how the state attorney's office, with the help of law enforcement, was able to get the full extraction that we have, because this defendant, on a recorded jail call, gave the passcode to his mother.
A couple of things, Your Honor, in retort. One is if if YNW Melly is like any other artist, the person who does their bookings is their manager, the person who had phone in hand. So if it's coming back to YNW Melly booking, that would suggest that it's the manager who has possession of that phone. The other thing that suggests he had possession of the phone is he had possession of the phone and he turned it over. Now, the fact that Mr. Demons knows the passcode is, again, not proof dispositive. That phone was being used by others while he was incarcerated. So other people clearly knew the password to the phone, or they could not have used it. And third, I'm not sure that Mr. Francois coming in here and saying it's Mr. DeMons' phone would be sufficient. I don't know that that would not be some form of hearsay, but at least that might start to approach some sort of foundation. All the foundation that's required by law to be adduced and elicited and put into the record is coming from the state attorney's mouth at that desk, and it's not in evidence. So all the things that she's saying establishes it as his phone are the very things that the case law and rules require be adduced before that jury. And so the fact that she understands that is evident from the fact that she is presenting it as the foundation for why she's trying to introduce this information. But this is not the forum to do it outside the presence of the jury. Do it in front of the jury if you have the witnesses, because otherwise it's hearsay. Her saying that Joe Blow told her that somebody else owns a phone is not legal foundation sufficient to satisfy the rules of evidence.
All right, so counsel, I'd like to see what you have and show me, we'll talk about how you, what evidence you're gonna have introduced to authenticate it and how to come in, all right? So we'll see everybody back at, let's say 1:15, all right? Thank you.
Thank you, sir.
Cell phone evidence, and I've just been told that they've actually wrapped up. So we will go ahead and get to your questions. YNW Melly, of course, is the South Florida rapper accused of murdering two of his friends, Anthony Williams and Chris Thomas Jr. They went by YNW Sack Chaser and YNW Juvie. We've been covering this case for a little more than a week now, and it's a pretty interesting one. YNW Melly, whose legal name is Jamel Demons, says that he did not commit these homicides, but the state says otherwise. So keep your questions coming to us on Twitter, YouTube, Facebook, Instagram, and TikTok, and we will get to as many of them as we can. For now, though, I want to start with